Welcome, everybody. Today we're going to look at the decision by a judge on a U.S. citizen that filed for their parents, but the U.S. Embassy denied the visa for the parents. So as we know, the mandamus lawsuit is typically filed when there is a delay. Not necessarily you don't like the decision of the embassy. So here, this plaintiff sued because they didn't like the decision of the embassy, and obviously the judge ruled against them. So we're going to go into the details of why the judge ruled against the giving the visa to the parents of the U.S. citizen. So this was filed at the District Court, Eastern District of Michigan. And we have a plaintiff here and defendants. So they list all kinds of defendants. So that's what they said at all, but they're defendants. So again, this is the decision by the judge where the judge had granted the order to dismiss that was filed. The motion was filed by the defendants. So here is the plaintiff. Plaintiff is a U.S. citizen. So the U.S. citizen is the one that filed this lawsuit, and they're the plaintiff. And then the relative are the visa petitioners. The visa petitioner is his parents, and they are Turkish citizens who reside in Turkey. The consular officer at the embassy conducted a visa interview for the parents, and then the same day they refused them the visa application, and then they requested additional information. That additional information was provided, and then nonetheless the application remained denied pending administrative processing. Now, the plaintiff claims that the defendants have unlawfully withheld and delayed the adjudication of the visa application, and he asked the court to compel the defendants complete the administrative processing and render a final decision on their application. But the final decision was, well, I don't know about the final decision, but a decision was already given by the consulate. They denied the visa. So a mandamus lawsuit is not going to fix that. So we'll see why. Plaintiff also claimed that the defendant's failure to adjudicate his parents' visa application violated his due process rights. All right, so the court's decision is that for the following reasons, the defendant's motion to dismiss is granted. The defendant is the State Department and everybody else that was listed in the complaint, and so their motion to dismiss is granted. So we're going to dive into the details as to why that was done. So here, just a statutory background: a non-citizen seeking a visa based on familial relationships, like a family relationship with a U.S. citizen, must complete a process. So there is a process for that prescribed in the Immigration and Nationality Act. So the INA, and the judge lists the INA statute here, and then said the first step is the U.S. citizen file a form I-130. So that is with the USCIS on behalf of the alien beneficiaries, on behalf of the parent seeking to have the alien classified as an immediate relative because they are a parent. So the USCIS approves the I-130 petition and then classifies the alien beneficiary as an immediate relative. Then the beneficiary may apply for an immigrant visa. So one of the requirements to get the visa is that the alien has to attend an in-person interview with the consular officer. It is the alien's burden to establish that he's eligible to receive visa and not inadmissible under any provision of the INA. So here are some of the statute of what that is saying. And a consular officer may refuse a visa if he determines such alien is ineligible to receive a visa under Section 1182 of this title or any other provision of the law. So basically, the consular officer has some discretion as to refusing the visa for the parents. The ultimate decision of whether to issue or refuse an applicant visa rests with the consular officer, and a mandamus lawsuit is not going to fix that. Okay. Once a consular officer conducts the interview with the applicant, the law requires that the consular officer issue the visa or refuse the visa. And here are the citations of the law. In the event that the consular officer refuses the visa, the officer may conduct administrative processing to determine if additional information from other sources may help establish applicant's visa eligibility. So here it says, if a visa applicant has not established that he or she is eligible for the visa, the consular officer must refuse the application. A consular officer may determine that additional information from other sources, so they can request additional information from other sources to establish whether that the applicant is eligible for a visa. So here's a factual background. I think we discussed all this already, but let's just take a look. So the plaintiff is a U.S. citizen, and his parents are Turkish citizens residing in Turkey. And the plaintiff is the U.S. citizen, filed I-130 for alien relative on behalf of his parents with the USCIS. So you know the process, I-130 then goes to NVC, National Visa Center, and then that gets sent to the embassy. So a year later, the USCIS approved the plaintiff's I-130 petition for the parents, and then sent the case to NVC for processing. So once the NVC completed its processing, it is sent the case to the embassy to schedule and conduct an interview. The consular officer at the embassy conducted the interview. That same day, the consular officer refused the parents' application, placed it on administrative processing, and requested additional forms. That form they requested was DS-5535. So DS-5535 was requested, and it looks like the parents completed the forms DS-5535 and submitted them. And still the application was remained refused, and there has been no movement in administrative processing. And then they filed a mandamus lawsuit alleging that defendants have unreasonably delayed the agency's action on parents' visa application under the Administrative Procedures Act and the Mandamus Act. And then what happened is the defendant, which is the State Department and everybody else, filed a motion to dismiss. The defendants give several reasons why the plaintiff's claim may be dismissed. First, the defendants state that the court lacks subject matter jurisdiction. The court does not have jurisdiction because the defendants have already taken the only action required under federal law. So they have already made a decision, that is refusing the parents' visa application upon completing the interview at the embassy. So plaintiff's claim is moot. So they're saying that we already made a decision. So basically, with the mandamus lawsuit, you're really asking them to make a decision. They already made the decision. And that decision was that they refused the visa. Second, the defendants contend that the plaintiff's claim are barred by doctrine of consular non-reviewability, which prevents the judicial branch from reviewing consular officers' decision to issue or refuse a visa. So basically, they're saying that the judicial branch cannot review what the consular officer did, and then they're saying the defendants' reason that by seeking an order compelling another decision by the consular officer, plaintiff essentially demands that this court set aside and reconsider the reconsider the decision that was already made by the consular officer. The defendants state that the consular officer has already refused the parents' visa application, so there's nothing to compel the defendants to do in this case. So with the mandamus lawsuit, usually you're trying to compel the defendants to do something, but in this case, they said we already made a decision, and the decision that we made was we were going to refuse the visa to the parents. Now you're filing a mandamus lawsuit, and with the mandamus lawsuit, you can't compel them to make a decision that you want them to make. The only thing mandamus does is to have them make move the case along, make a decision. Here they say we already made a decision, we refuse the visa. In addition, defendants state that the plaintiff failed to establish a claim of due process violation because his parents do not possess a constitutional right to enter the United States. Okay, let's just go to the bottom. And then they have all these legal reasoning, and then so they say for the APA mandamus, under a Mandamus Act, a court has authority to compel an officer, an employee of the United States, to perform a duty. So do your job. That's the only thing they can do, but you can't tell them if they already made a decision to make another decision. So it says a writ of mandamus is only appropriate where the petitioner has exhausted all administrative remedies and defendant official owes petitioner clear and non-discretionary duty. Similar under APA, the federal agency is required within reasonable time to proceed to conclude a matter to present into it. However, this remedy does not apply where the agency at issue is committed to agency discretion by law. I mean, the consular office has a lot of discretion. So under either the Mandamus Act or the APA, plaintiff must show that the defendants owed him a non-discretionary have failed to act upon that duty. The defendants contend that the plaintiff's claims are moot because the defendants have taken all action they're legally required to take, so there's no actual controversy between the plaintiff and the defendant. So basically they're saying that we already taken the action, which was we refused the visa. So that was the action that we took. They're saying the crux of the disagreement between the plaintiff and defendant is whether defendants have any continued non-discretionary duty whether to adjudicate the parent's visa application. The plaintiff contend that the consular officer's initial refusal did not satisfy his obligation under this law to either issue or refuse the visa because they requested the additional documents. They're saying that because they requested the form DS 5585, that the consular officer did not reach a final decision, but it kept it under a consideration pending. They're saying that it was not a final decision because they asked for more information, which was a DS 5585, and therefore it was not final. In contrast, defendant contend that the plain language of the law, the consular official's only non-discretionary duty was to issue or refuse the visa after the consular interview. So the only non-discretionary was either you refuse, you give the visa, or refuse to give the visa. And there's nothing in the law requiring defendants to conduct or conclude administrative processing or render a final decision as it relates to administrative processing. The problem with plaintiff's approach is that it does not point to any law or regulation requiring plaintiffs to complete administrative processing, thereby re-adjudicate visa application that has already been refused. Defendants have submitted evidence, and plaintiff admitted in this response that consular officers refused plaintiff parents' application. Okay, so here they're stating they're going to cite a couple of cases. An unpublished Sixth Circuit case supports the conclusion that pretty much the judge is reasoning on, and that it is saying that there is a U.S. citizen plaintiff husband and a wife that is a Yemeni citizen. The husband filed a form I-130 to get his wife, so who is an immediate relative, and bring her to the U.S., which was approved by the NVC and sent to the U.S. Embassy for visa interview. At the visa interview, the consular officer doubted the legitimacy of the husband and wife's marriage and refused the wife's visa. So pretty much this is the case is that a U.S. citizen husband filed an I-130, it was approved by NVC, went to the interview in the U.S. Embassy, and they said, we don't believe this marriage is bona fide. We don't believe this is a legitimate marriage, and they refused the visa. Later, the plaintiffs submitted additional evidence of their marriage, but their petition remained at the NVC for re-adjudication. While awaiting a decision on the re-adjudication of the petition I-130 at the NVC, the plaintiffs filed a petition for the writ of mandamus compelling adjudication of the visa application, claiming that their application remains in administrative processing. So basically, the Sixth Circuit held that the government fully discharged its clear duty to adjudicate the wife's visa application when the consular officer denied it. So basically, when the consular officer denies it, you cannot file a mandamus lawsuit or based on Mandamus Act or the APA for them to make a different decision. They already made a decision. Mandamus is just if your case is stuck for a long time, to get it moving again. But you don't know what decision they're going to make, and you may not like the decision, right? So the plaintiff points to the FAM, the U.S. Department of State Foreign Affairs Manual, which state that the applicant has presented new evidence to overcome a prior refusal. The government should reopen and re-adjudicate itself. So the court is saying, however, the FAM does not carry the force of law because it is just a manual. The plaintiff also cites other statute which states that if the grounds for an applicant refusal can be overcome with additional evidence, the applicant indicates he intends to submit such evidence, documents relating to the application may be kept for a period of 1 year. Even if it did that, the use of the term may indicates discretion, not non-discretionary duty. I mean, it's very interesting. The court is cognizant of the tremendous split in the authority on the issue whether the government has non-discretionary duties to complete administrative processing after the denial of visa application. Courts across the circuits and even within the circuits have ruled inconsistently. So let's take a look. The final ruling is going to go all the way down by the judge. So the judge ruled that for the foregoing reasons, the government's motion to dismiss under the federal rules of civil procedure is granted, and this case is dismissed without prejudice. So yeah, so you cannot use a mandamus to typically, at least what this judge is saying in this order, is that if a visa application has already been denied by the consulate, you're not going to file a mandamus lawsuit and tell them to reopen the case and to approve it. That's not what mandamus lawsuit is for. All right, thank you very much for